those ones who do not have such foundation in place. And for me, I feel like even say after I left the uni, I am still learning throughout the years. The best channel I've personally found, well, at least quite useful to me, is basically two sources. One is the basically the Gartner articles. They indeed provide a lot of industry best practices. And quite often the businesses.
Bye. Next class is coming in. Yeah. So thank you so much, and keep in touch. Bye for now. Thank you.
No problem.
I had this one doesn't connect that well with what do you call it?
Zoom? Teams?
Zoom.
Oh,
yeah.
really?
Yeah, the sound was so bad. I had to make do with my laptop, and that's why a little bit delayed.
No, that's fine. That's fine. No, it's all good.
I'll log out of things. Hopefully I'll log out of everything.
No,
Your phone, not mine.
That's mine.
Thank you so much.
Right, afternoon everyone. Bit of a quick start to today because the last class went a bit late, but all good. Hopefully everything will be working. Right, so welcome back to Mistake. Today we're going to start getting into the weeds of the mistakes legislation, which we have kind of been circling around over the last week by looking at what the pre-existing law was prior to the mistakes legislation being enacted in the late 70s, and also those doctrines or areas of law which were unaffected by the passage of the mistakes legislation, namely non-est factum and rectification. Non-est factum, as you remember, we did on Monday, when one party who has signed an agreement which generally says to the world, I agree to what is contained within the agreement, can argue, I didn't know what I was signing because I was misled in some way. The fact that I didn't know what I was signing was not due to my own carelessness, and what I thought I was signing was radically or very different or substantially different from what I actually signed. And we saw when we were looking at non-est factum that the courts, this is a very narrow exception to the general rule that if you sign something you're bound to it because signing is evidence that you agree to what you've put your signature to. This is a very narrow exception, and in applying non-est factum we see that the courts, the common law courts, were very concerned about a finding of non-est factum, what effect that would have on other parties, and that was a highly relevant consideration for determining whether or not non-est factum should be applied or not. What impact will a finding of non-est factum have on parties who have relied on the existence and enforceability of this agreement? Because you remember the effect of non-est factum is that the contract is void ab initio, there was no contract, and no part of it is enforceable. So we looked at that on Monday, and then on Wednesday we looked at the equitable doctrine of rectification, where you could show the courts that you and the other party had a common intention about one part of the agreement, and for whatever reason that common intention was not reflected in the contractual document itself. You could apply to the courts for rectification to say, Your Honour, this was not our agreement, the other party knows that's not our agreement, it would be unconscionable for the other party to rely on the written agreement which doesn't reflect our actual agreement, please rectify the document, which would be to change the document itself and then enforce that document as changed or as rectified. And then we saw at the end on Wednesday this idea that although generally rectification requires a common intention, that both parties have the same intention about the part of the agreement you're wanting to have rectified, where only one party is mistaken, such as in the case of A. Roberts, you might still be able to argue rectification on the grounds that the other party knew you thought the written document says something different and went ahead anyway, and by their actions, in this case by their silence, effectively misled the mistaken party into thinking that there was agreement on this particular point and that the parties had agreed what the mistaken party thought was the actual agreement. So remember, in that case, the council had drawn up the agreement on the strength of the builder's tender document. The tender document had the completion date of 1955, and the council wrote up the agreement based on the tender document, all being in line with the tender document, save for they changed 1955 to 1956, didn't say anything. And then in subsequent meetings where it was very clear that the builders thought that the end date was still 1955 in accordance with their tender document, the council said nothing. and thus misled them by their actions. And in that case, the court said, you could argue rectification even though both parties never agreed as to the date. And the reason you can argue rectification is that you, the council, cannot resist a plea of rectification by bringing forward evidence that you thought that the end date, or you intended the end date to be 1956, because by your actions, you led the builder to think the end date was 1955. You are stopped or prevented from leading evidence to the contrary. Therefore, both parties had the same intention, and therefore we can rectify the document. So rectification, changing a written agreement to reflect what the parties had agreed to, and for whatever reason it wasn't reflected in the agreement itself. Okay, and it's an equitable doctrine based on the idea it would be unconscionable for one party to enforce the written agreement when they know that's not what their actual agreement was. And we've already seen that, if I can get the document camera to zoom properly, you can see that both rectification and non est factum are continue to have force after the passage of the Contractual Mistakes Act and now, of course, the CCLA. Today we're going to look at the CCLA in some detail, as I've said, but before we go on, are there any questions at all about what we did last week, about the law relating to formation and rescission prior to the mistakes legislation, the law relating to non est factum, or the law relating to rectification? Yes, Lucy. So rescission was the equitable doctrine which held that there was no contract because it would be unconscionable for you to enforce this agreement when you knew the other party was mistaken. Yeah, it's what actually happened in the majority of Taylor and Johnson. Doesn't apply after the passage of this legislation. Other questions? Everyone happy so far? You ready to dive into the weeds of the mistakes legislation? I will take that as a passionate and agreeable yes. Fantastic. Okay, in that case, let's get into the mistakes legislation. Remember, of course, the CCLA 2017 was only a drawing together of pre-existing law. The law relating to mistakes was passed in the Contractual Mistakes Act 1977. The law under the CCLA is, for all intents and purposes, the same. The annoying thing is that all the section numbers have changed. So all the cases we're going to look at today refer to the previous section numbers under the Contractual Mistakes Act. And so in my slides, I'm going to have the old section numbers and then beside it in square brackets the current section numbers that correspond to the old ones. Because the law is the same, these cases are a good statement of the law, or still stand true even with the passage of the CCLA. Okay? Just the section numbers have annoyingly changed. Okay, CCLA, what have we talked about? Well, we've said that... Actually, before I start that, I want to say something. No, we'll come back. Sorry, we'll come back. Okay, so what have we said? Well, the purpose of this subpart is to mitigate the arbitrary effects of mistakes on contracts by giving courts the power to grant relief when you satisfy Section 24. We'll look at Section 24 in a moment. And we've seen already the interpretation section that a mistake is a mistake whether of law or fact. And that a mistake in the interpretation of a document is a mistake of law. So the mistake about a document is a mistake that can be granted relief under the Act. However, Section 25, you cannot be mistaken about the interpretation of the contract itself. Or at least you can be, but that is not grounds for relief under the Act. So if the contract says A and you think it means B, you cannot argue that that is a qualifying mistake for the Act to which you should be granted relief. You may be able to get some other form of relief, perhaps rectification or non est factum. Perhaps you could argue that the contract should be interpreted the way that you want it to be, but you can't argue mistake under the Act. We've already seen that the Act replaces the common law in equity, but not in relation to non est factum, rectification, undue influence, fraud, breach of fiduciary duty and misrepresentation, the Illegal Contracts Act and Frustrated Contracts Act. Which means that you could have a number of different claims arising from the same fact pattern. You could have a mistake that you argue grants you the right to rectification under equity, but also, in the alternative, grants you relief under the Act. You could also have a situation where one party has misrepresented something that induced you to enter into the contract, which grants you a claim for misrepresentation. But that misrepresentation might lead you to have a mistaken belief about some aspect of the contractual bargain, which also grants you a remedy under the contractual mistakes legislation. And you could argue both in the alternative. We will see that there are some key differences in relief or the remedy granted by the courts for a contractual mistake, which might make it more advantageous to argue misrep rather than mistake, but it might not. But the point is you could argue both in the alternative, or you might choose one because one gives you a better result. Yes, Lucy.
The CCLA replaces everything in common law to do with mistake, but for the...
Yes, that's exactly what Section 22 says. Has the rules of common law and equity governing the circumstances in which relief may be granted on the grounds of mistake. But this doesn't affect anything in subsection 3, which is effectively that list. Okay? So, let's see when a mistake can be argued under the Act. The meat of the Act or the legislation relating to mistake is Section 24. And this sets out when there is a qualifying mistake for the purposes of the Act. And it's a long section which has 3 parts to it. And in order to satisfy Section 24, you must show that the mistake satisfies each of the 3 clauses under subsection 1. So you must show A and B and C. They're cumulative and you must show each one. Let's start off with Section 1A. Under Section 1A, there are 3 types of mistake or 3 situations which count as mistakes for the purposes of Section 24. And these are in the alternative, okay? So for subsection 1A, you can either be in 1A1, 1A2, or 1A3. The first type of mistake is what's known as a unilateral mistake. That is, one party was induced to enter into the contract by a mistake that was material to that party, and the existence of that mistake was known to the other party. So I walk into your art gallery, I see a piece of art on the wall, I say, I can't believe you've got a real Goldie, original Goldie, and you're selling it for only $50, what a steal. I will buy that Goldie. And it turns out that it's not a Goldie, it is a rip-off or a print, and you know it's a print, and you know that I think it's a Goldie, well, in that case, you've got an arguable unilateral mistake. I am mistaken as to the subject matter of the agreement. I think that this is a Goldie, it's not, and you know that I think it's a Goldie because I've been saying it. That would arguably fall under 1A1. 1A2 is when both parties are mistaken and both parties are influenced in their decisions to enter into the contract by the same mistake. Sometimes described as a common mistake. So I enter into your art gallery, you are advertising this piece of art as a Goldie, I think fantastic, I would like to buy a Goldie, and I buy the Goldie, and both of us think it's a Goldie, and we both genuinely believe it's a Goldie, but we both turn out to be mistaken, and it is instead a knockoff artist in the style of Goldie, but not Goldie himself. In that case, both of us are entering into the contract under the same mistake. That is, we both think that this painting is by Goldie, and it's not. That would be a section 24, 1A, Roman 2 scenario. And then we've got the last one, which is sometimes described as a mutual mistake, where both parties enter into the agreement influenced by different mistakes about the same subject matter of fact or law, or same matter of fact or law. So I enter into your art gallery, I see this painting on the wall, I think that's amazing, that's a Goldie, I won't say anything though, and I'll go buy it, I'll say I'll have that painting there. And you think, oh, that's fantastic, someone's buying this rip-off Goldie, and you sell it to me thinking it's a rip-off Goldie. I think it's a Goldie. It turns out we're both mistaken, and it's actually a Cézanne. Easy mistake to make. So in that case, you think the painting is by some random. I think it's by Goldie. Turns out we're both wrong, and it's actually by Cézanne. In that case, we are both making different mistakes about the same subject matter. The painter of the painting. Yeah.
How was the same subject matter in that example?
Because it's we're both mistaken about who painted the painting. So it's the same matter we're mistaken about, but we've made different mistakes about that. So effectively, you've got the right position, and you've got two wrong positions, each of us holding a different wrong position. Okay, so you've got one of those three mistakes. So that's or. You don't have to show them all, obviously, because they're different scenarios. You have to show one of them, however. And then, under section 24(1)(b), you have to show that the mistake resulted at the time of contract in a substantially unequal exchange of value. So you have to show that the consideration given by each side was substantially unequal, or there was a substantially disproportionate consideration flowing from one side compared to what the other side was giving. Now, you remember back in formation days, you would have learned that the courts don't care as to the fairness or otherwise of the bargain, just as long as there is a bargain. They won't look into whether or not objectively that was a fair exchange. When it comes to relief from mistake, however, the courts will look at the effect of the mistake on the objective value of what you are exchanging. So if I spend $100,000 on a painting in your art gallery thinking it's a Goldie, and it turns out to merely be someone in the style of Goldie, the courts will say, okay, well, you bought this for $100,000 thinking it's a Goldie. At the time of contract, what is the value of a painting done by someone in the style of Goldie? Is that substantially less than $100,000? If so, then section 24(1)(b) would be satisfied. So you have to satisfy that. And then finally, you have to satisfy 24(1)(c), which is to say that the contract itself, either expressly or implicitly, cannot place the risk of mistake on the party arguing mistake. What do I mean by that? Well, it's probably easiest to demonstrate in the example of a sale of goods. If you buy something on Trade Me, often it's a good idea, if you're selling, but it's a good idea, often you'll have on the description, as is, where is, or something like that, which indicates that you, the purchaser, are agreeing to buy it in its current condition, no matter what that condition is. And that the vendor, the seller of the goods, is not making any promises or warranties as to its condition. So if you buy the fridge thinking it can go down to 0 degrees, and it can't, it can only cool things down to 6 degrees Celsius, and you're mistaken as to the quality of the fridge, you can't argue mistake, because the risk that you were mistaken as to the quality of the goods was placed on you in the contract itself, when it said as is, where is. Or even more expressly, the contract might say something like, the vendor makes no guarantees or warranties as to the quality of the goods. It is up to the purchaser to satisfy for him or herself the quality of the goods, and agrees to accept the goods no matter what quality. Okay, that is putting the risk that the purchaser makes a mistake as to the quality of the goods onto the purchaser. So under section 24(1)(c), the purchaser can't then turn around and argue, I was mistaken. Well, no, that's the exact type of mistake that the risk was placed on you under the contract. Just Lucy. And that's also could be argued by implication. We're going to look at implication next week. But some contracts, you could argue, because of the nature of those circumstances, by implication place the risk of mistake on one party. And I think a great example of this would be something like a garage sale. When you go to buy goods at a garage sale, I think you can make a very strong argument that by implication, the risk that what you bought is not as good as you thought it was is on you. That the vendor is making no warranty about the goods. It's just saying, these are the goods, come and look for yourself and take them if you want. But if it turns out that the quality of the fridge you're buying from me in a garage sale is not as good as you expected, sorry, the risk is on you. That's not expressed in the contract because there's probably no express contractual terms, but by implication I think you can make that argument. Yeah, Lucy. Yes. It just means come and get it from as it is in this condition where it is right now. It just means the risk is on you, effectively. Okay, so for section 24, you need to satisfy A, B, and C. So you need to satisfy each. And failure to satisfy any one of those three conditions will mean you don't have a qualifying mistake. Okay? Happy so far? Yes?
How would you include the word C, one C, when you say there's like implication of mistakes? Would that be relatable to how you interpret the contract?
Yes.
How would you reconcile?
Great. So question about the interplay between implication and interpretation. We're going to look at that probably next week when we look at implied terms. But effectively, you interpret the words that are there, and then, if necessary, for a number of different reasons, you might imply a term in to give business efficacy because of the nature of the trade that you're in, by law, etc., etc. So you interpret the contract first, and are there any gaps? Do we need to imply a term in to fill the gap? Or should we imply a term in to fill the gap is roughly how it works. Good question. Cool, okay. So section 24, you have to satisfy all three. And that gets you a qualifying mistake. And that allows you to go to section 28, where you get relief. And the first thing to note about the relief is that you have no right to anything. The court may make any order that it thinks just. And in particular, but without limiting the ability to make an order for whatever it thinks just, the court may do any one of these things here. It could actually enforce the contract as it is. It could cancel the contract. It could vary the contract. It could grant you restitution or compensation. It could vest property in one party, or assign property, or transfer property. The point is, it could do anything it wants, but you have no right to anything. Which is different, for example, when you argue misrepresentation, because you get damages as of right if you have a misrepresentation under the CCLA. Similarly, if there's a breach of contract, you get damages as of right under the common law. The only question is how much those damages should be. Here, you get nothing as of right, but on the other hand, you could get anything. So, the options are limitless. What you would do, and what the courts would probably agree with, is you would argue, Your Honour, I have a qualifying mistake for these reasons, very good. Under section 28, in order to make an order that is just, you must do this. And then the other side will say, no, there's no qualifying mistake. And even if there was, the just outcome is for you to do this. And then the court has to figure out probably which one of those two options it will go with. Okay? But the point is that you have no right to any relief whatsoever. And you can see here, the drafters of this statute were trying to get away from the quite narrow remedies that could be granted in, for example, rescission. They didn't want a situation where the only options was cancel the contract in its entirety or enforce it in its entirety. They wanted to give discretion to the courts to make any order they think is just. And so that's what they've done. However, that's not the end of the matter. So there's a wide discretion to do all sorts of things. But there are also limitations written into the statute itself which the courts have to be aware of when they are granting a relief under section 28. The first is right back in section 21, 2b, where it says that the powers to grant relief must not be exercised in a way that prejudices the general security of contractual relationships. So the courts right away are being told, do not over-exercise your power to grant relief in such a manner that it will mean that no one can rely on written documents, written contracts. Or at least uncertainty is there's too much uncertainty in the ability to rely on written contracts. Furthermore, we have the limitation we've already seen in section 25. There's no relief that can be granted for a mistake in the interpretation of the contract itself. And finally, under section 31, third parties who have been granted property that was the subject matter of a mistaken contract cannot have that property taken off them by an order under Section 28 when those third parties knew nothing of the mistake and have acted in good faith. So if I buy something off you under a mistaken contract and then sell it to a third party, and the third party has no idea about our contract or the fact that you were mistaken, you cannot, under an order for Section 28, get that property back from the third party. The court is unable to take that property off the third party and give it back to you. Instead, you will be limited to compensation, probably, for the value of that property, which of course doesn't help you when the thing that I've sold to a third party is your grandmother's heirloom that's been passed down your family for generations, but Section 31 says you can't get that back and you can only get something else. Yes, Lucy?
Can you not get it back because the third party is innocent?
Yes, that why should the third party be deprived of his or her property when they've done nothing wrong, and because then if there would be intolerable uncertainty for people taking goods, or anything really, but if not only do they have to worry about whether or not their agreement to buy the property is certain, but whether the agreement before that was certain, or the agreement before that was certain. It just means that third parties are protected and they can rely on the strength of their agreement that they've had. Yeah, so certainty and because they're innocent. Okay, is everyone okay? Any other questions so far? Make sense? Okay. The thing about this Act is that it was drawn up by a committee. And the committee was made up of mainly of academics, which is not a good way to get consensus or agreement among the committee members. And indeed, there was violent disagreement between the committee. At least one of the committee members wanted all contracts under which any party had entered into for any mistake to fall under this these sections. And then for the courts to do whatever is necessary to do justice. And then you had others in the committee who said, well, that's just far too far-reaching. That would undermine the certainty of any written agreement because you'd never know if the other party is mistaken or not. And furthermore, it just encourages people to lie about whether or not they were mistaken to get out of a bad bargain. And so you had these two views about contract law and about mistake, and both of those views came into the legislation. And so you have this tension between doing justice between the parties to that agreement when one or both of them is mistaken, and the wider concerns around contractual certainty, about the ability to rely on the objective agreement, and the concern that written agreements should be able to be relied on without too much fear about being set aside for mistake. And you see this tension being replicated in the cases we're going to look at next, where the courts in New Zealand were trying to figure out how far does this legislation go? How far should it go? And you see that quite early on you have quite a wide interpretation of qualifying mistake under Section 24, and then the Court of Appeal rowing that back and saying, well, that was probably too far, until we get the case from last year, Watson and Zhao, where you have a very, very narrow interpretation, I would argue, of the Contractual Mistakes Act, such that it's hard to see many mistakes at all being covered by this legislation. Okay, but we will do that after a 5-minute break now. I just thought we'd have a couple of short breaks today. So we'll have a 5-minute break now until 1:45, and we'll come back and we will look at the case of Conlon and Oslands. Okay, so 5-minute break. I'll see you at 1:45. Right, let's get back to it. We'll have another break at 20 past for 5 minutes. Okay, I'll leave you to read this slide yourself about caveat emptor. Caveat emptor is that old Latin tag meaning buyer beware. Essentially, prior to the mistakes legislation, mistakes as to quality, which caveat emptor dealt with, were not actionable. That is, buyer beware. You bought something, you were mistaken as to its quality, too bad. It has been overtaken by the Consumer Guarantees Act for goods as a consumer. Aside from that, would caveat emptor still apply? The short answer is no. Any mistakes are actionable theoretically under the contractual mistakes legislation. The only question that might impinge upon it is substantial unequal exchange of values. Some mistakes as to quality might be so minor so as not to fall within the section 24(1)(b) requirement. So that's just what I'm getting out there. We'll leave that for now and look at this fantastic case, Conlon and Oslins. Now, this is the first case in the Court of Appeal dealing with Conlon and Oslins, with the mistakes legislation that really made waves. And it's between an elderly widow who immigrated to New Zealand from Latvia and cannot speak very good English, and an evil property developer. He's not actually evil, he's fine. The reason I say that, though, is that you're the developer or you're the developer's lawyer, and you read the first sentence from the majority judge, or one of the majority judges. Mrs. Oslins was an elderly widow who made a mistake, or is an elderly widow, beg your pardon, who made a mistake. And you think, we've lost. And you'd be right, you did lose. At least from the very front, you have the president saying why, or saying which way his sympathy lies. This case, as we'll see, is confined to its facts, which is a passive-aggressive New Zealand judge way of saying it's wrong. But you confine it to your facts because you know the judges in question personally and you still want to get invited round to their house for drinks. So you don't say it's wrong, you just say it's confined to its facts. What does that mean, or why is it confined to its facts? Don't worry about it, just means it's wrong. Yes, Lucy? One of the parties. Yeah, one of the parties. Mrs. Oslins is the widow, Conlon is the other party, the purchaser. We'll come to that. But I think it's a great example of how hard cases or sympathetic cases can make bad law. You really see that the majority in this case really feel sorry for this elderly widow who made a mistake and really want to find for her, even if the words of the statute perhaps do not suggest she should win. Anyway, so you had a widow who owned a house in Palmerston North. That wasn't the mistake, but I'm allowed to make that joke because I grew up in Dannevirke and Palmerston North was a big smoke when we grew up. So we go to Palmerston North for birthday parties because they had a McDonald's. Anyway, so she lived in Palmerston North And she had a house. And behind her house she had a garden which had a lot of fruit trees, chickens, ducks. And she used it actually for a food source as well as for a garden. And then at the edge of the garden there was a corrugated fence, iron fence, and on the other side of it was a paddock, which was mown. And her husband died, she wanted to sell off the paddock. And so she said to her solicitor, I would like to sell the land out the back. And the solicitor didn't go to the house to have a look and see what she was talking about. Instead, the solicitor got the title, saw the plans, and saw that there was the house on one part of the title and then 4 separate lots at the back. And so the solicitor drew up an agreement for the sale and purchase of those 4 lots at the back. Unfortunately, those 4 lots were her garden and 3 lots making up the paddock. The purchaser, Mr. Conlon, came to buy the property, thought, that's fantastic, I'm going to subdivide it and put houses on there. And he bought all 4 of the lots that were in the agreement, or at least he wanted to. Unfortunately for Mrs. Oslands, she never intended to sell her garden. She wanted only to sell the paddocks, and it was due to the solicitor's mistake that the garden was included in the contract. Yes?
If this solicitor screwed up, why didn't she go after him instead for like breach of contract or negligence?
Fantastic question. Put a pin in that. We'll come back to it. The short answer is she doesn't want the money. She wants her garden. But yes, keep that in mind because we'll come back to that. So the solicitors mistakenly put all 4 lots into the contract. Mr. Conlon came on and they agreed a price. He signed, she signed, and then it came to the time for settlement and she refused to transfer the lots or the property because she did not want to transfer her garden. And so he brought an action for specific performance, forcing her, or what he wanted to do was force her to transfer the property that she'd signed up to. Specific performance, as we've said before, is an equitable remedy whereby the court tells one party to do their side of the bargain, to enforce their agreement, and is the normal remedy for when you have a breach of a sale and purchase of land agreement. So he's seeking to enforce the agreement and so sues for specific performance. She doesn't want to give up her garden. Remember, under the contract, she very clearly sold her garden. And at the High Court, the purchaser was successful. He signed an agreement to buy 4 lots. She signed an agreement to sell 4 lots. We're going to enforce the agreement as it objectively stands. And she appeals to the Court of Appeal. And by majority, Justice McMullen and President Woodhouse, they refuse specific performance. And they grant her relief under the Act. What that relief is, we're never told because they send it back down to the High Court to deal with. She also argued non-est factum in the alternative. All 3 judges said that non-est factum was not available to her for 2 reasons. One, she wasn't misled as to what was in the agreement. If she was, the only person who misled her was her solicitor. We saw in Bradley West that being misled by a solicitor is not good grounds for non-est factum. She was therefore probably careless in signing something she didn't intend to. And also, it's hard to say that what she signed was really radically different from what she intended. So non est factum, none of the three judges held non est factum applying here. But the majority did hold that the Contractual Mistakes Act applied. And therefore relief would be allowed under Section 28, which used to be Section 7. So that's the legislation they're dealing with at the time, and this is the comparable legislation nowadays. Okay. What part of the Contractual Mistakes Act applied? The equivalent of Section 24, 1A3. Whoops, where are we? Here, 1A3. Where one party and at least one other party were each influenced in their respective decisions to enter into the contract by a different mistake about the same matter of law or fact. So what were those different mistakes? Well, this is what President Woodhouse said. Each mistakenly believed that the written document correctly represented a mutual intention which did not exist. He mistakenly thought she was consciously selling all of the land at the rear of her house, including the garden. She mistakenly thought he was buying merely the land beyond the high fence. To put the matter in another way, each had a mistaken impression about the boundaries of the tract of land being bought and sold. Now, that last sentence is palpably not true. The last sentence. Each had a mistaken impression about the boundaries of the tract of land being bought and sold. He was not mistaken about the boundaries of the tract of land being bought and sold. He intended to buy 4 lots, and that's what he thought he was buying, and that's what objectively he did buy. Only she was mistaken about the boundary of the land. So that last one is wrong. He mistakenly thought she was consciously selling all the land at the rear of her house, including the garden. And she mistakenly thought he was buying merely the land behind the high fence. Well, if that's true, those are still different mistakes about different things. He's mistaken about her subjective intention. She's mistaken about what he was actually buying. Well, even if that's true, that is not a Section 24(1)(a)(3) example, because you need to show that they had different mistakes about the same thing. And they do not have different mistakes about the same thing, according to President Woodhouse. What you can say is they each mistakenly believed that the written document correctly represented a mutual intention which did not exist. Maybe you can get it under there. But the other two formulations do not make sense. So, there was a Section 24(1)(a)(3) example, according to President Woodhouse. Now, he didn't discuss Section 24(1)(b), the substantially unequal exchange of value. The other judge in the majority, Justice McMullen, did. And he effectively said that the price of 40 grand was far too low for 4 lots, and that the value of 4 lots should have been something around 52, 54 grand. And that was substantially disproportionate exchange of value, and therefore Section 24(1)(b) was satisfied. Yes, Lucy? So it's not about how much you know it's worth. It's the objectively, at the time of the contract, what was the contract what was each side actually given, and was that substantially unequal? So it's not what she thought it was worth, it was what objectively it was worth. That's the question.
So why was it so low?
Why was it so low? Because she didn't realise she was selling 3 lots, arguably. Did she have any idea about the value? Probably not. So it doesn't matter what she thinks, it's just objectively, was the agreement a substantially disproportionate exchange of value? And in this case, the majority held that it was. And President Woodhouse sent it back to the High Court to determine relief. And it's quite funny, because of course, going back to the High Court, what's the first option the High Court could do under Section 28? declare the contract to be valid and subsiding in whole and enforce it. So the High Court could have actually just specifically enforced the contract again. And so that's why President Woodhouse does something a little cheeky. It is almost inevitable, I would think, that if the matter is sent back for further attention in the High Court, as I think should happen, the judge will reach the conclusion that there should be no order for specific performance, taking into account the very unfortunate way in which this contract came into being, certainly, I think, through no fault on the part of Mrs. Oselitz. So effectively, the President of the Court of Appeal saying, we're sending it back to the High Court to exercise discretion under Section 28. Don't exercise that discretion in that way. So don't find specific performance again, even though technically under this Act you can. So it'd be a ballsy High Court judge who then turns around and says, thanks, I'm going to specifically enforce the contract. That's the just thing to do. What is also interesting is a number of times President Woodhouse talks about how it was through no fault on the part of Mrs. Oselitz. In a sense, that's correct, because it was her solicitor's fault, but then again, he's acting for her. The reason why that's relevant is because of Section 27. That one of the factors to take into account when fashioning relief under Section 28, one of the things the courts have to take into account is the extent to which each party caused the mistake of the other. So if you're seeking relief under the Act, the fact that you contributed to the mistake is something to take into account. So that's why the President of Woodhouse is constantly saying this was not due to her fault. It was instead the solicitor's fault. But he doesn't say that. And he says there's no specific performance order. Before we get to the I'll just say one more thing. I also chuckle about this. I am satisfied that the object of the Contractual Mistakes Act is promoted by construing it to include the present case. That's not what later cases have held. That's not at all how it's been read since then. Okay, so let's just think about what the majority judgment means. You have a written agreement which objectively says you're buying and selling 4 lots. You, on the strength of that agreement, intend to buy 4 lots. You sign up to it, so does the other party. And then after you've both signed, the other party can turn around and say, that's not what I intended. And that contract can then be set aside, or some other relief can be granted to that mistaken party, even though at the time you entered into the contract, you had no idea that the other party was mistaken. What does that do to contract law? Yeah?
Undermines contractual certainty.
Yes, great. How does it undermine contractual certainty?
Because at any point you can sign a contract and the other party can go, no, we didn't want to sign up to it. And if they're like a sympathetic party, there's not much you can do.
Yep. So it encourages parties, at the very least, to try their luck, to try and get out of bargains that they've signed up to by saying, I made a mistake. Now you're going to have to lead some evidence to that, but at the very least, it undermines the ability for anyone to place any certainty on what appears to be a binding written agreement. It encourages parties to lie. And furthermore, let's come back to the point you made earlier. Who's breathing the biggest sigh of relief? The lawyer. Who's actually the party who stuffed up? The lawyer. Who's protected by judges who used to be lawyers? The lawyer. I mean, if you were the other side, you'd be so annoyed that this guild was protecting its own from, as you say, the consequences of his action. What should have happened, I would argue, is that the sympathetic elderly widow loses her garden, and then she can turn around and sue the real negligent party, the lawyer. But as it is, she doesn't lose anything, so she's got no grounds to sue the lawyer. because she hasn't lost anything. So that's the majority judgment. It also means, well, we'll come to that. But yes, before we go on, yes, Lucy.
Is that how you said that the CMA is the Contractual Mistakes Act?
Yeah.
Is that still enforced or is that another way?
No. So the Contractual Mistakes Act is what the CCLA is now. So the CCLA took up the Contractual Mistakes Act. Okay. There is a strong dissent from Justice Summers, which I think is quite devastating. First of all, he says there was an argument that said there was no agreement entered into because she never intended to enter into this agreement, and therefore, as a matter of formation, no agreement was ever entered into. And he says, no, that argument is inadmissible under the Act. Remember section 23, subsection 4, there is a contract for the purposes of this subpart where a contract would have come into existence but for circumstances of the kind described in this Act. So if you're arguing mistake under the Act, you cannot then argue also that no contract was ever entered into under formation principles. You assume that there's a contract and then you go to the rest of the Act. And he says, Justice Summers, okay, prior to the legislation being passed, Mrs. Oslands would have had no grounds for relief. She made a wholly subjective mistake, which the other party did not know about, and therefore there would have been no grounds for relief under, well, certainly under rescission or rectification. Arguably, you could argue non est factum, but for the other reasons we've said, it wouldn't have applied here. But he says that doesn't matter. The Act is a new start. It overtakes the previous law. So whether or not she would have been successful under the previous law doesn't matter. So does the new Act apply? And he says no. Section 24(1)(a)(3), under the old CMA it's section 6(1)(a)(1)(3), but don't worry. He says that section, which the majority is relying on to grant relief to Mrs. Oslands, doesn't apply to this fact. Why? Because on the one hand, you could argue that actually they were both mistaken, but they were making different mistakes about different things. He thought she intended to sell 4 lots. She thought the contract said only 3 lots. So she was making a mistake about what the contract said. He was making a mistake about what she intended to sell. Well, those are different mistakes about different things. And that doesn't allow you to get relief under section 24(1)(a)(3). You need different mistakes about the same thing. But more fundamentally, the purchaser made no mistake at all. He intended to buy 4 lots, and that's exactly what he bought. He intended the contract, and that's what he got. So the only potential way you could grant relief is for a unilateral mistake 1A1, which is when she's made a mistake and Mr. Conlon knows about it, but quite clearly he didn't know about it in this case, so it doesn't apply. Furthermore, if we allow this reading of section 24(1)(a)(3) to apply, then every single unilateral mistake, whether it's known or unknown to the other party, will fall within section 24. And if that's the case, then section 24(1)(a)(1) is completely superfluous and unnecessary. Because if a wholly subjective mistake, which the other side doesn't know about, falls within section 24(1)(a)(3), then why do you need Section 24(1)(a)(1), which requires knowledge? You don't. So if the majority is correct, Section 24(1)(a)(1) is swallowed up entirely. Why did Parliament require knowledge for unilateral mistakes if you can just say unilateral mistakes without knowledge can be grounds for relief under Section 24(1)(a)(3)? Furthermore, this would undermine the requirement for the court to apply their power under the Act in a way to ensure the security of contractual relationships. This completely undermines contractual security and certainty for the reasons we've talked about. How would anyone buying a property know whether or not that agreement in writing will stand or not if the other party can just turn around and say, I was mistaken? But Justice Summers was in the minority. And so the upshot of this case was that a purely subjective mistake, which the other side knew nothing about, can be grounds for relief under the Act, which is far, far, far beyond anything that common law or equity allowed prior to the passing of the Act. And effectively you get something like the will theory of contract, where as long as one party is mistaken or doesn't intend what the contract says, there will be relief for that party under the Act. And interestingly, Professor Sutton, who was one of the members of the committee that wrote this legislation, after Conlon and Oslands was like, yep, fantastic, this is exactly what I intended. Because he thought that's exactly what it should be. Any mistake whatsoever should be covered by the Act, he thought, and then it's up to the courts to fashion a remedy to do justice. And in some circumstances where the mistake is wholly unilateral, maybe there will be no relief. But the point is that the courts get to exercise their discretion in all cases. He wanted to throw the sections out wide to catch all mistakes and then give it to the courts to fashion relief.
What is the argument for allowing the court to grant relief in any mistake?
Because that would do justice for the parties. Poor old Mrs. Oslands never intended to sell 4 lots. Why should she be bound to an agreement that she never intended? The whole point of contract law is to give effect to parties' intentions to be bound, at least according to the will theory. That's why, effectively. But again, he would say, I'm not necessarily saying she should escape from her obligations, but it would be up to the courts to try and fashion a relief. Yeah.
If he wanted there to be so much judicial discretion, like everything to be open to judicial discretion, why does the legislation then also include that, like, but nothing should under my consideration?
Because Professor Sutton was not the only one drafting this legislation. Drafting by committee, right? You get a bit of a Frankenstein's monster of a section. So you had other people in the committee who disagreed with him. But there was also, I think, a change between the first draft and the second draft, which included that requirement of contractual security of contractual relations, because people were concerned about that. The other response that I've seen half in support of Conlon and Oslands. So cards on the table. I don't think Conlon and Oslands was the correct decision. But President Woodhouse and Justice McMullen, you don't get to be on the Court of Appeal if you're an idiot. Okay? So you have to give a bit of deference to someone that you don't agree with, particularly when they're Court of Appeal judges. Similarly, people who disagree or think that the judgment's fine, like Professor Sutton, again, not an idiot. So I've got to give some deference there. The point is that people do disagree with me. I think I'm right on this point, but that's fine. The other way in which people have said a different result could have been fashioned, or a better result could have been fashioned, is remember that the purchaser was seeking specific performance. The courts, it's an equitable remedy. The courts have a discretion as to what to do there. They don't have to have to grant specific performance. So they could have said that the Contractual Mistakes Act doesn't apply, but we're not going to grant you specific performance because it would be unjust in these circumstances. And instead, we're going to enforce the contract. We're going to give equitable compensation to the purchaser and only enforce part of the agreement, potentially.
Sorry, quick question. When you say a purely unilateral mistake, what does that mean? Like, you said something about knowledge before.
Yep.
So,
Okay, so a unilateral mistake, in this case, a purely unilateral mistake, as in Mrs. Oslands was the only party who was mistaken here. And I mean purely unilateral in that the other party had no idea she was mistaken. Whereas under section 24(1)(a)(1), a unilateral mistake is only covered by the Act when the other party knows, in this case, Mrs. Oslands was mistaken. So what I mean here is that in Connell and Oslands, he had no idea she was mistaken and she was still granted relief for her purely unilateral mistake, is what I mean by that. Good? Cool. Other questions? Yes, Lucy. What this case stands for, the upshot. What's the consequences of this case? What are the consequences of this case? The consequences is that the Contractual Mistakes Act was read exceptionally widely. And towards the end of the 80s, that decade in which Connell and Oslands was decided, the Court of Appeal started to realise that perhaps that's not such a great idea. Until you reach Polger and Butland, where you have a 3-judge bench of the Court of Appeal reading down Connell and Oslands. And you'll notice that those 3 judges in this court case, 2 of them are different, but one of them is Justice Summers, who is, of course, the one who gave the strong dissent in Connell and Oslands. But he didn't write the judgment, he just agreed with Justice Hardy-Boys, but I can see that Justice Summers, I would argue, had a strong influence on this judgment. Okay, so what happened in Polger? Mr. Polger was the chief executive of a company which he had built up and had been the managing director for about 50 years. Unfortunately, the company was in dire financial straits. It owed about $7 million of debts, and the creditors were circling. They wanted their money. The company didn't have the resources to pay all of their debt. However, the company was in negotiations and indeed had entered into a contract, which had not yet been executed but had been signed, which would have sold part of the company's business, and it was hoped raised enough money to pay off the debtors. Unfortunately, in the words of every single creditor throughout debtor throughout history, I just need more time. The business needed more time. So the chief executive, Mr. Polger, thought, I just need some time from my creditors, or from the company's creditors. And if I get that time, the company will sell off its business and be able to pay the debt. And so therefore, Mr. Polger sent this letter to all creditors. This letter serves as advice of intention to make payments to all creditors as soon as possible. As you may be aware, Magnum Corporation, apparently it's a real thing, have purchased the grocery interests of our company, and until finalised, we are unable to release payments. We ask your tolerance while we execute this matter and advise we will make good all outstanding matters within 90 days. The writer personally guarantees that all due payments will be made. Thank you for your consideration in this matter. Oh dear. Well, it's not a smart thing to write. Well, it was fine, apart from that second to last sentence. The writer personally guarantees that all due payments will be made. Remember, the debts were owed by the company. And the basis of limited liability means that any debts owed by a company are not owed by the company's shareholders nor by the company's executives. So the the creditors of the company were owed money by the company, but no one else. But then you get this letter from Mr. Polger saying all debts, or the writer personally guarantees that all due payments will be made. You can see where this is going. One of the companies that was owed money couldn't wait, sued for the amount of money owed and placed the company into receivership. And what happens there is that all the assets of the company are sold off or are given, and the proceeds are given to the creditors in a strict order. Those that have securities such as mortgages or liens, then the IRD is up there, employees are up there. Unsecured creditors are generally down the bottom, and generally when a company is in financial difficulty, the reason it's in financial difficulty is because it doesn't have enough assets to satisfy its debts. So once its assets are sold off, at least some of the creditors are going to be without any money. And so the unsecured creditors of this company were not paid. And so Butland was owed about $11,000, didn't get anything back out of the company. Luckily, Butland, though, has got a letter from Mr. Polger, under which Mr. Polger says, I personally guarantee all due payments will be made. Yes, Lucy?
When Mr. Polger said I personally guarantee all due payments will be made, is he promising for somebody else, not himself?
Good. Well, that's the question. What does he mean by that? Because he, the plaintiff, Mr. Butland Limited, brought an action against Mr. Polger personally for the amount of $11,000. And it brought summary judgment proceedings. What's summary judgment proceedings? What does it mean?
I think it's like before you properly go and hear the case, the proper prosecuting, you actually have the case and decide whether to move on.
Yeah.
Properly hearing it.
Effectively, it's where one party says, Your Honour, the other side has no arguable case, therefore grant me what I want without a trial. When you are a junior litigation lawyer, that's what you do. You go sit there in court with 30 other nervous junior litigation lawyers and you get summary judgment applications because they are quick, they're not a trial, and they're done what's known as on the papers, so no witnesses are called, you just give the documents that support your side. But the point is, you are saying the other side has no arguable defence. And so to resist a claim for summary judgment, all you need to show is you have an arguable defence. And so this case is a summary judgment application. The creditor is saying Mr. Polger has no defence at all. Not that he's going to win, just he has no defence. And he's trying to say, yes, I do have a defence. We will come on to that defence in 5 minutes' time. We'll have a break now. We'll come back at 28 past. And we will finish Polger and Butland. Lucy?
I haven't seen you in a while.
Hello.
Now, Wednesdays have been the best. Like, did I tell? Oh, actually, I'm just chatting. I'm sorry. Yeah. I just was kind of confusing about in the Justice Somers dissent of Osmond's case. Like, Mrs. Osmond and the other side was talking about different things.
Yes.
And I don't know why somehow it like remind me of the Dundee Farms case, which I know is on a different topic.
Yes.
In there, it was about titles and the area of the farms.
Yes, yes.
But in there it was saying they were talking about the same thing, but I don't know why in there it was talking about the same thing, but in here the judges say they were talking about different things. Does that make sense?
Yeah, no, it does.
Yeah.
And it's always good to try and compare it to other cases you've done that seem similar.
Yeah.
So remember in Dundee Farms, both parties had gone and seen the farm.
Yeah.
They knew what they were buying in substance.
Yes.
Like in the real world, they both agreed that they were buying this.
Yeah.
And it was just whether the contractual agreement reflected that intention.
Yeah.
Whereas here, she thought she was selling just the paddock, and he thought he was buying the paddock and the garden,
Okay.
right?
Yeah. But could it in that case that they thought they were like selling titles but not like, so what they thought is different as well in the Dundee Farms case?
Right, so could you argue a Contractual Mistakes Act under Dundee Farms?
Yeah.
Potentially. They both made different mistakes about the trouble with that is they might run up against Section 25. That you can't get a relief for a mistake, which is a mistake in the interpretation of the document.
Yeah.
You could argue that in Dundee Farms, they were both mistaken as to what those 4 titles meant. Because they both thought it was the farm itself.
Yeah.
Maybe.
Yeah, so I think in the Dundee Farms they were similar because they were, I don't know, having trouble understanding the thing that they were selling on the contract.
So you could argue, okay, so Dundee Farms, you could say they were both mistaken as to what the contracts affect,
Say.
but that's the trouble. They're both mistaken as to what the contract says.
Yeah.
And that runs into Section 25. You can't be mistaken about what the contract says.
Yeah, that makes sense.
So they could only really argue rectification, I would argue.
Okay. Yeah, but in this case, it's different because it's one side about what Mrs. Osmond have in mind, and the other side is what they have on the contract.
So that's another problem with Connell and Osmond's, is what
Yeah.
mistake did she make? Well, she made a mistake as to what the contract says.
In her mind.
Because she thinks the contract says the paddock,
Yeah,
and it
yeah.
doesn't. It says the paddock in the garden.
Yeah.
So that's again a mistake under Section 25, which is another reason why Connell and Osmond's is a bad decision.
Yeah. Yeah, it's quite bad. I'm like confused
Yeah,
about
yeah,
it.
yeah, there's-
Yeah, but I think makes more sense now.
Is that okay?
Yeah, yeah. Thank you.
No
I'll
problem.
ask a quick one before we have to get to
Yeah,
the
yeah, sure.
lecture. Do we need to know the rescission and stuff, right? Obviously, the CCLA replaced all of that stuff.
Yes, yes.
So we don't need to worry about that
No.
essentially because you're going to be arguing, you're going to be looking at CCLA for the exam, right? And second question, with like the knowledge and stuff, obviously you've gone through and done like this case, but in the legislation it says you need the knowledge. So am I gonna, like, for that section that you said, number 3?
No, so Section 3 is different.
Yeah,
You don't need knowledge for Section 3. You only need knowledge for Section
1. Oh, okay. So if that comes up, because this case looked at that, didn't it? And then and you said that they needed knowledge in that case, which was wrong, right? Or like I'm
So sorry, Conlon and Oslands needed knowledge.
Yeah, what was like? I'm
Yeah,
kind
so
of confused.
okay, so Section sub clause 3
Yeah,
is both parties are mistaken, are making different mistakes about the same thing.
yeah.
There's no need for knowledge.
Oh, yeah.
There is need for knowledge where only one party is mistaken.
Yeah.
The other side needs to know about it.
Okay, and then
So that's why she couldn't go under 1 because the other guy didn't know about it.
yeah,
She argued 3 successfully.
yeah, because you don't need to.
You don't need knowledge. But if that's the case,
Yeah,
that if she's successful for 3, then any unilateral mistake unknown to the other party would fall under 3.
yeah.
So why do you need knowledge for unilateral mistakes under 1 if you just go under 3? There's
Yeah.
no need to.
So will the
So-
next cases clarify that, or do we?
Yeah. So Colin Osland's overturned.
Thank you.
No problem. Yeah. No, we're going to get started, but yeah. Is it a...
If you said that the CCRA 8%. So then if it 8 it, how come we still have to look at the CMA? Why not just look at the
Because the cases we're looking at were under the CMA. The cases we're looking at were under the CMA. So they're still relevant.
Can you say that again?
So the CMA existed until 2017. These cases were pre-2017. So the law at the time was the CMA.
Oh, for the cases.
Yes, yeah, that's right. Okay, so you can't go after the company because the company's in receivership, so you go after Mr. Polger, who you allege gave a personal guarantee in this letter that he sent you. And the defendant, Mr. Polger, says, that's ridiculous. That letter was not a personal guarantee. Clearly it's not a personal guarantee. I would have been stupid to send a personal guarantee when the company is owed $7 million. Clearly I'm not taking on board all of that liability. And it goes to the High Court, and the High Court says, yes, you did. And you owe $11,000 under this personal guarantee. And so Polger appeals to the Court of Appeal. The first question is, what is the legal effect of this document? Is it actually a contract? And the court says, yes, it was. It's a unilateral contract. Just like a reward poster is a unilateral contract, if you cast your minds back to offer and acceptance, he's sending an offer out to everyone who is owed money by the company. And he's saying, if you do what I ask you, I will personally guarantee your debts. And so the plaintiff, Butland Industries, agreed and accepted that offer by doing the performance asked. And the performance asked in this case was not to find Mr. Polger's cat or anything like that. It was instead to forbear from suing for 90 days. So the courts read this letter as saying, we need 90 days. If you hang fire, do not try and get your money back for 90 days. Don't try and enforce your loan for 90 days. I will personally guarantee that all payments will be made. And that's a unilateral contract. Objectively, this was the offer of a personal guarantee of the debt by the defendant. The reason why is very simple. The words, personally guarantee. And the fact that that was a stupid thing to do isn't by itself reason not to read it at face value. The other argument he raised was, I clearly wasn't writing in my personal capacity, I wrote as chief executive of the company. I was guaranteeing the loans on behalf of the company. And the court says, well, that's undermined by two things. Firstly, you didn't write I on behalf of the company, you wrote I personally. Secondly, why would the company guarantee its own debts? That makes no sense at all. You don't guarantee your own debts, you already have to pay them. So that, writing that letter and saying, it was effectively saying, if we ensure that the company will make this payment, don't sue us for 90 days and the company will pay you. I mean, that's already owed to those creditors. So objectively, the court said this was a personal guarantee. There was acceptance by the plaintiff because they didn't sue for 90 days. Okay, so there's a personal guarantee in writing. That's a problem for Mr. Polger. Can he escape under the Contractual Mistakes Act? He argued, look, I if this is a personal guarantee, that's not what I intended. I never intended to be personally bound to this letter. And just like Mrs. Oslands never intended to sell 4 lots, I should be able to escape the consequences of what I wrote and what I signed under the mistakes legislation. And you can see the absolute problems that arise from Conlon and Oslands. That anyone can get out of any written contract or try to get out of it by simply saying that's not what I intended, which is his argument here. This isn't what I intended. Mrs. Oslands got out of her contract when she didn't intend it. Why can't I get out of mine? It just says that it has no effect. The court rejected this argument and said there was no qualifying mistake here. Firstly, just like arguably Mrs. Oslands, the mistake of Mr. Polger in this case was as to the legal effect of the agreement that he had signed. He thought this letter did not personally guarantee him. It turns out it does make him a personal guarantor. The trouble with that is Section 25 specifically says a mistake in the interpretation of a contract is not a qualifying mistake for the purposes of the Act. He was mistaken as to the effect of the letter. The letter was part of the contract, and therefore it is not a mistake which qualifies under the Act. Already we are poking large holes in the reasoning of Conlon and Oslands. But more fundamentally, just like Justice Summers said in Conlon and Oslands, the plaintiff in this case made no mistake at all. Butlin Industries thought it was getting a personal guarantee, and that's exactly what it got, a personal guarantee. So the only party who was possibly mistaken was Mr. Polger. It's a unilateral mistake, and therefore it doesn't fall within 1A2 or 1A3, because that requires both parties to be mistaken. It can only fall within Section 1A, 24.1A1. And for that to apply, Butlin Industries would need to know that Mr. Polger was mistaken. And it didn't know, so it doesn't apply. And then you get the kicker at the end of the judgment, where he says, look, the words of Justice McMullen are not to be read as referring to what each party believed the other intended, because then the parties' respective mistakes would have been about different things. Him about her intention, hers about his, yet he held that this was a case for para 3. This is an important distinction. For Conlon and Oslands is a decision on particular facts. Quote, it is not authority for invoking the Act where one party misunderstood the clearly expressed intention of the other, or where one party meant something different from the plain meaning of his words. For then the mistake is one in the interpretation of the contract, and the party making it cannot avail himself of the Act. Conlon and Oslands was absolutely authority for that proposition, but they've just decided that Conlon and Oslands is incorrect. But I really wish they would have come out and said that. They didn't. They said it's to be read on its own particular facts, which means it only applies to that situation and no other. It was wrong. Conlon and Oslands was wrong. Our law would be better if the courts would just come out and say that. In the present case, Mr. Polger says he did not intend his letter to mean what it clearly did mean. This is a mistake in the interpretation of the contract and it can't be relied upon. The respondent did not make a mistake of that kind. Its mistake was that the contract meant what it said, and that was no mistake at all. Those words can be applied to Conlon and Oslands as well. So Polger and Butland makes it very clear that where one party is mistaken as to what they think the contract means, they can't argue mistake under the Contractual Mistakes Act. Yeah. We'll talk afterwards, okay, Lucy. Okay. So, Conlon and Oslands is confined to its facts. So it seems clear that for this section 24.1a3, you need three different possibilities. You need the correct position, you need Party A's mistaken belief about that subject matter, and Party B's different mistaken belief about that same subject matter. And then we've also got this point about the interpretation of the contract. So the interpretation of a document which is then incorporated into the contract itself cannot be a valid mistake for the purposes of the legislation, because that would run afoul of Section 25. So if you reasonably but erroneously think that the contract says X and you intended X, but then it turns out that the contract actually means Y, you are prevented from arguing mistake under the Act. But you might be able to argue rectification, and indeed that's, for example, why probably Dundee Farms would come under rectification but not under the Contractual Mistakes Act. Questions at all about that? Do you understand? Yes, sorry.
Sorry, what do you mean by, in the previous slides, the correct position of the three different possibilities?
Okay, so under 24.1a3, you need two different mistakes about the same thing, which means there needs to be a correct position which both parties don't have. They both need to be mistaken about this particular thing, but they need to be making different mistakes. And the problem in Conlon and Oslands and Polger and Butland is that that's just not what was happening there. Yeah, Lucy. Avail myself of a which? Oh, take advantage of it. Use it. Use it. Cool. Okay. Any other questions? Okay. One of the major differences between the mistakes legislation and what existed prior to the mistakes legislation is this requirement in Section 24.1b that the mistake, to be a qualifying mistake, needs to result in a disproportionate exchange in value. Rescission, or prior to the mistakes legislation, the value of the mistake didn't really come into it. It was more about whether the mistake was about the fundamental nature of the contract or not. Here, the question is slightly different. Whether there's this unequal exchange objectively at the time the contract was entered into. Effectively, the legislation is asking us to decide, is it unfair? Was the bargain unfair because of this mistake? And this is the way it writes unfair. Is there a substantially unequal exchange in value? Because if there is, that is grounds for the courts to get involved under Section 28. There haven't been heaps of discussion around substantially different. But at least in the High Court case in TriStar, the court was prepared to say that a difference in value reflective of the GST amount was enough to trigger Section 24(1)(b). And these were in the good old days when GST was only 12.5%, not 15%. So back then, 12.5% difference in the value of the contract, at least in the High Court in TriStar, was held to be enough to trigger Section 24(1)(b), which is not actually a very high threshold. So what happened in TriStar? It's a case about the lease of property out at the airport. And the lease agreement contained within it an option to purchase. So the tenant could at any time exercise its option to stop being a tenant and instead to buy the property. And the option to purchase, the lease, first of all, was for about 90 grand a year, plus GST. So the amount was 89,144, plus an additional 12.5%. However, under the option agreement, the sale price was $720,000 flat. There was no mention of GST. And when there is no mention of GST, that means that GST is included in the price. Okay? So when you go buy something from the shop, it never says inclusive or well, it usually doesn't say inclusive of GST, it just usually says the price. That price, if it doesn't say anything about GST, always includes GST. They don't add it on afterwards. So same thing here. Objective observer of that price would say that $720,000 includes GST. Because there's no mention of GST, that means that GST is included in the price, which means that the vendors, the sellers of the property, get less money in the hand because they have to take some of that $720,000, 12.5% of it, and give it to the IRD to account for GST. And so the vendors argued that that sale price was a mistake and that they should be granted relief under the Act, or the agreement should be rectified, or that the purchaser should be stopped from enforcing that agreement, which is roughly the same thing as rectification. I'm not sure what it added to that agreement, to that argument. At the High Court, the mistake argument under the legislation was upheld. The vendors were mistaken as to how much money they would get in the hand, which influenced them to enter into the contract. And it was a unilateral mistake under Section 6A1 or 24.1A1. So the vendors entered into the contract under a mistake that was material to them, and the mistake was known to the other party. The High Court held that section applied, even though the purchasers had no actual knowledge that the vendors were mistaken. Yeah.
How does that not count as a mistake as to the interpretation of the contract?
Yeah, great. Yeah, it does. It should be. Yeah, I think it should be. I think that's the answer, is that Section 25, this is a mistake in the interpretation of the agreement. You misinterpreted what that agreement... Well, just let me think about this. You could argue that, no, we know what that means, but we always intended it to say plus GST. So it's not so much what it means, but what it actually said, I suppose is. So we're not saying we think $720,000 without anything else means plus GST. We know it doesn't mean that. We're saying that the contract should have said $720,000 plus GST. It's a rectification argument, really. We were mistaken as to what the contract literally said, not how that contract, as it's written, should be interpreted. Yeah, I think that's the reason why. But it's always a good test to say yourself, why is this not a Section 25 interpretation issue? And I think the answer is because it's not so much about the interpretation of the document, it's about what the document actually said. It should have reflected that it's plus GST, and it didn't. But the High Court held that they could get relief because this was a unilateral mistake that wasn't actually known to the other side, but the other side had constructive knowledge. That is, they should have known that the vendor was mistaken. And that's good enough for Section 24(1)(a)(1). And furthermore, that the difference in GST was a substantially unequal exchange of value for the purposes of subsection Clause B. And so it went to the Court of Appeal. And the major question was, what sort of knowledge is required for Section 6(1)(a)(1), or 24(1)(a)(1). And the Court of Appeal made it clear that the answer is there has to be actual knowledge. Now, actual knowledge may be inferred from proved circumstances. So in this case, the fact that the lease document and all the other documents said plus GST is a fact which you might use to then infer that the other party knew that this document should also be plus GST. So even though they say, oh, we didn't know that, you might infer that they actually knew that. You're not saying a reasonable person should have known that. You have to go one step further. Yeah.
But couldn't you say in the contrary that since all the other figures said explicitly including GST, the fact that it's explicitly absent in this case means that you should...
They decided to do so.
Yeah.
Yep, you could. Yeah. The question, though, would be a question of fact, arguing about the evidence. But the point is that you use that evidence not to show what a reasonable person should have known, but what this person actually did know. And that's what you need to prove, that they actually knew. The fact that a reasonable person would have known is good evidence, because the argument is, Your Honour, a reasonable person would have known that they meant plus GST. This person's reasonable, therefore they knew. But the point is you have to go one step further. You have to use that evidence of what a reasonable person ought to have known to prove the other party did know. It's not enough to show merely constructive knowledge. And the main reason for this is that all the other times we've applied this, the case laws required actual knowledge. The report leading up to this Act said actual knowledge was required. So the drafters of this Act suggested that's what they intended. But I think the best argument for why actual knowledge is required is that there are a whole bunch of other statutes where Parliament has said known or ought to have known. So they have specifically put in a constructive knowledge limit. They chose not to do so here, and so that suggests that Parliament was requiring actual knowledge. And because there was, as a finding of fact, no actual knowledge, Section 24(1)(a)(1) was not satisfied. So, you need actual knowledge for section 24.101, and according to the High Court, a substantially unequal exchange of value is also GST. We'll finish TriStar on Wednesday. We'll very quickly do Watson and Zhao, and then I also want to do a very brief 20-minute 20-minute question from a previous exam on mistake, okay, and on the application of the Act. Okay, I'll see you on Wednesday. Cool. Thanks, guys. Yeah, sure.
So when you say about the substantial
Unequal exchange value.
yeah,
Yeah.
which is just like how courts maybe come down to how they think whether it's unfair.
Not whether it's unfair, but whether it's substantial unequal exchange of value, which effectively is saying, is this a fair exchange?
Okay, how does it similar or difference from equity when it says it's unconscionable to do the agreement?
So unconscionability is not, so it is a different question. Similar sort of ideas of like fairness, but unconscionability is more, you can't enforce this agreement, you should not enforce this agreement because it's not agreed.
Yeah.
Which, yes, I mean, also has notions like this. But I mean, this statute doesn't mention fairness. That's me extrapolating why they have that. So it's saying like a minor mistake that there's no real difference in the bargain is not covered. Thanks, guys. It's not covered by section 1.
Yeah. For that, you know. Okay. Yeah. Thank you so much. Thank you.
With the contract thing, you say you can't touch, like, it's not about the interpretation of the contract. Can't be. So I'm kind of confused with like the GST and stuff like that. If I was in an exam and there was, I don't know what it means by like interpretation of the contract versus like something on the fact of the law. I'm kind of confused.
So it can't be a mistake as to, does this contract mean X?
Yeah.
You can't say, I thought that this letter was not a personal guarantee.
When it did say in the contract it was personal guarantee, but like let's say if the contract didn't mention GST, then I can.
Well, because, okay, so yeah, so you have to formulate what the mistake is to make sure it's not a mistake, it's the interpretation is agreement. So they're not saying, we thought whenever the contract is silent, the price is silent, that it excludes GST.
Yeah.
Because that's what I said. That it would be plus GST. So they weren't arguing that.
Yeah.
They were saying, we left off plus GST. We should have put it on there. We made a mistake. We thought it included plus GST, and it didn't. So we're not saying we misinterpreted the document.
That's what it said.
Yeah.
But we're talking GST in general, right? Is that what?
No. So we're saying this document says $720,000.
Yeah.
We thought it said $720,000 plus GST. We thought that was the actual words, but it wasn't.
Yeah.
We're not arguing that $720,000 means plus GST.
Oh, this is gonna. Do you get it? Like it's kind of confusing.
Yeah.
So now I'm confused too.
I'm confused as well. So hold on, it's not about, you're saying it's not about the interpretation of the contract. So they're not arguing that GST, like obviously GST is included, right? So they're not arguing that part. That's what it says.
It's effectively a rectification argument.
Yeah.
That the contract doesn't say what we thought it said.
Yeah.
So I agree to sell you peas and beans, and the contract only says peas. I'm not arguing that the contract means peas and beans. I'm saying that we thought that the contract was for peas and beans. We thought the writing was going to be peas and beans, but it wasn't. It was just peas.
Oh, okay.
So I'm not saying peas means peas and beans.
It's just that it should have included
Included peas and beans.
Because you're not touching the interpretation.